Hey there, students. We are live on exam day for AP Government. All right, good to see y'all. Some of y'all are in the Crowdcast. Some of y'all are in YouTube. I'm going to be taking questions via Crowdcast, crowdcast.io/Tom Richey. I'll be occasionally looking at the YouTube chat as well. Now, we've got, we see the squad here. Okay, we've got here people about to take that exam. Now, we're seeing some very interesting things going on with the AP Physics test takers. Okay, there does seem to be there seem to be some issues with students having trouble submitting their exams. Now, one thing that we want to note here. All right, we already see some Clemson haters coming in here. All right, I see how it is. I see how it is. So let's go ahead and get to it. Okay, the AP government exam is starting soon. Now, first of all, you should take a look at my video while you're waiting for your exam. I don't think it would be a bad idea. I just put out a new video making very clear what is cheating, what is not. Okay, what does the College Board consider to be cheating? What does the College Board consider to be a legitimate use of notes? Okay, so as far as that goes, basically it's just you can't rely on other people. Anything that involves using other people, that is a no-go. All right, so as far as that goes, ladies and gentlemen, what I promised y'all today is we would look at some samples. Okay, so first of all, if you go to marcolearning.com, there are free practice tests for 10 subjects. I'm going to go ahead and throw a link into the chats in YouTube and Crowdcast. Okay, so as far as that goes, I did not paint the wall just for the live stream. Okay, so something here, I'm going to go to marcolearning.com where they've got free practice tests in a variety of subjects. Okay, so 10 different practice tests at marcolearning.com. Let's go ahead and see what they've got for us. Okay, so the Marco Learning Practice Exam, we can go in here. You go to marcolearning.com, free resources, and then we go to practice tests. Okay, so marcolearning.com, they've got a practice test in 10 different subjects. Okay, so going from there, then you will then go to whatever subject. We've got U.S. government and politics. Okay, so we can get that practice test. So with that, we see that our exam is going to have, the argument essay is going to come first. Okay, so as far as that goes, what we want to make clear here, if you go to my Instagram, now I'll be shouting out occasionally to people who are following me on Instagram.com. Okay, so as far as that goes, we go to Instagram.com here, and we can see that I've got this graphic that I've recently posted from my friends at Marco Learning. Okay, so my friends at Marco Learning here, we are going to, we're seeing here that we have 30 minutes to log in. At 3:30 p.m. Eastern, you need to be logged in, ready to begin your exam. Now, once you're logged in, you're welcome to take a look at my new video that is explaining what is and what is not cheating so that you're very clear on that. 25 minutes for the argument essay. Okay, so you've got the argument essay in 25 minutes. You will get 5 minutes to upload. Then we've got 15 minutes for the concept application question, and then 5 minutes to upload that. Okay, so that's something we've got here from our friends at Marco Learning, making sure everybody understands that. You're welcome to go to my Instagram and take a look at that, take a screenshot so that you've got that somewhere or have that open in a window. Thank you, Anime Web Nerd, Grace Dave, or Arasi Dave. Okay, so Araceli Davis. Okay, so we've got, yes, it's Italian. Or wait, is that, okay, which flag is that? Okay, I'm trying here, okay? Julie, Sarah, and Rob, thank y'all so much for the recent follows. But yes, take a look at what we've got here as far as this timing guide. So you want to understand that these are going to be timed separately. All right, so your first task is going to be to take a look at the argument essay and answer it. Now, I've got an argument essay rubric that you're welcome to have open. You're welcome to print out. The link is in the YouTube description, or you can just search for AP Government Argument Essay Rubric 2020, and it will bring you there. If you're on YouTube, it's in the video description, AP Government Argument Essay Rubric 2020. And let's see what happens here. Okay, so going through, we've got a few College Board links and then AP Government argument essay. Okay, so looking at that, we've got our 2020 rubric. We can download that is available to you. Okay, so with that, we want to make sure that we have a thesis that it's supported by 2 pieces of evidence. Now, the evidence is scored with 6 possible points. You can earn up to 3 points for each piece of evidence, so up to 7 points. 1 point for the thesis, 3 points for each piece of evidence, depending on how deep. Now, first of all, the first 2 evidence points, they don't have to be tied to a thesis. They can come from anywhere. So that's something. Now, I'm hoping if you're watching here, you plan to have a thesis statement. Okay, so you plan to have a thesis statement here. Now, for these points, it has to support your thesis. And then for the last points, you have to explain how you're supporting the thesis with this evidence. Now, note here that there's also a requirement here that in order to get all of the points, there will be 2 points denied to you if you don't use one of the foundational documents in the prompt. So what we've got to note here is where you see these 3 foundational documents, one of them needs to be used as evidence. Okay, one of them needs to be used as evidence here. And so your second piece of evidence can be another foundational document. It can be a Supreme Court case, or it can be, a piece of legislation or something like that. I think that it's safest to think in terms of foundational documents and court cases. Okay, so as far as that goes, the Articles of Confederation, the U.S. Constitution, Federalist 70, one of those must be in your essay to get full credit. The other one can come from anywhere else. Can I use 2 of the 3? Yes, you can use the U.S. Constitution and Federalist 70. Now, another thing that I recommend, because I feel like you've got plenty of time to do this essay, and the exam is scored based on what they call positive scoring. You're scored based on what you've got on the paper, not what you got wrong. So I typically recommend, if you can do it within the time limit without shorting the evidence you're using, you can have a third piece of evidence just to make sure. Okay, so I think having a third piece of evidence, not a bad idea. Thank you, Alexander Gonzalez and Mallory Johnson, Ethan Caesar, and Yanni Brooks. Yanni Books, okay, and Mango Maddie. That's a great handle there, Mango Maddie. All right, super ready. Yanni Books is super ready. Okay, I'm glad to see that is happening there. That y'all are super ready. And so with that, now let's look at the question. We're going to have to use one of these and then an additional piece of evidence. I recommend throwing in a third, perhaps. Now, the United States Constitution establishes the responsibilities of the executive branch as part of a series of checks and balances among the 3 branches of the U.S. government. Over time, the powers of the presidency have expanded beyond that which is stipulated in the U.S. Constitution. Now, this is background. This is basically just giving you some background so that you can appreciate that. So we understand that the Constitution has given us 3 branches of government, and it's got the executive branch. Now, what we're seeing here is we are focusing on the powers of the presidency have expanded beyond that which is stipulated in the U.S. Constitution, what some people refer to as the imperial presidency. We see that the president is more powerful today than the framers intended. Now you're going to develop an argument, one side or the other. Remember, either side can be taken. You will never be given a prompt here where you cannot take either side. So develop an argument about how the expanded powers of the presidency affect the balance of power within the U.S. government. Okay, so what you want to note here is, how has it affected the balance of power? Has it made things more balanced or less balanced? Okay, has it helped the balance of power between the branches, or has it hurt it? Now, you want to think about what would be another piece of evidence. And I'm thinking Federalist 51, because we're talking about the relationship between the branches. So you're thinking in terms of, what can I use here to make this more comprehensive? So going from there, let's go ahead and take a look at the powers of the presidency. So I'm going to put this here where we can see this. This is a Google document that I've put together. I'm going to go ahead and share that. We're going to put that in the YouTube chat and the Crowdcast chat. Okay, so we're going to make sure that y'all have access to this if you want to have this to look at on your own as well. Okay, so we've got this Google document here. For those of you, let's see. So we've got that, and then we will put this in the description. Okay, so I'm going to put on YouTube, I'm going to put it in the video description. Okay, so we're going to note here. Let's see. So argument essay sample response for 2020. Okay, so argument essay sample response, and then of course free practice exams available at marcolearning.com. Okay, so and that's for other exams that you're taking as well. Okay, so free practice exams. Okay, so we're going to make sure that that's there as well. So we've got this. So we've got the, for those of you on YouTube, you can refresh and you will see that we've got that there. So y'all should have access to the document. So we're going to go in here and take a look at Q4. Make sure that I'm screen sharing properly. Okay. So as far as that goes, now you only have to make an argument for one side. But what I would do for brainstorming a little bit is I'm thinking about, okay, how would we say that this is beneficial? It's balanced. I would think Federalist number 70, New York Times versus the United States. That's a great one for showing how the Supreme Court is able to keep the executive branch in check. New York Times versus the United States is an excellent case for that, because the Nixon administration, they wanted executive privilege. The New York Times should not be able to publish this. This is what's called prior restraint, okay? And then the Articles of Confederation, we could say, we could use that to make an argument there. So going from there, imbalanced or harmful, we could look at Article 1, Section 8, the powers of Congress. Also, we could use the War Powers Resolution. Okay, so that's something that we might note there. I'm going to go over, remember, every argument essay prompt is going to be able to be argued on both sides. And I'll occasionally be checking Instagram and thanking new followers. Okay, so we will be thanking new followers on Instagram. So just keep following, keep supporting there, and I'll be shouting out occasionally. So again, this practice exams available at marcolearning.com if you want to see the prompts. So although the presidency has become more powerful in relation to the other branches of the United States government since the Constitution was ratified, it is beneficial to the government to have an energetic executive, and that powers are still balanced because of the growth of the power of the Supreme Court. Okay, so remember, when we're looking at this Marco Learning Practice Exam, looks like here we are using Federalist number 70 because we're talking about an energetic executive. In Federalist number 70, the thing here is that it is focusing on an energetic executive. Okay, we need energy in the executive branch. A unitary executive is beneficial because the executive branch requires energy in order to be effective. That is Hamilton's argument. Now, to make sure that my evidence is supporting topic sentence, or supporting the thesis, we want a topic sentence. Notice how I'm making two claims. So I see here, it's beneficial for the government to have an energetic executive, and then the powers are still balanced because of the growth of the power of the Supreme Court. So we see here that we have a clear and argumentative topic sentence. Okay, so we're going to see here that a clear and argumentative topic sentence we see first. And then this says here, the framers of the Constitution intended for the presidency to be energetic. The Articles of Confederation did not have an independent executive branch of judiciary, just a Congress. In creating a presidency, the framers wanted an executive that could act independently from the legislative. Now, what I've done here is I've just kind of I call this peppering in, that you've got a couple pieces of evidence that are like your big evidence, but then I've got other stuff that I might occasionally pepper in. Are the Articles of Confederation going to get me, like mentioning this here, going to get me like all 3 points? No, but it's not going to hurt. Might as well bring that in there that the Articles didn't have, but I've made a legitimate reference to a foundational document. But what I'm really going to develop here is Federalist 70. So if you can pepper in other evidence, I don't think that that does anything to hurt you. It can only help as long as you're not running out of time. But 25 minutes is plenty of time to write what I'm putting together here. In creating a presidency, the framers wanted an executive that could act independently from the legislative, at least to an extent. This is evident in Federalist number 70, in which Alexander Hamilton, who was present at the Constitutional Convention, answered the objections of the anti-federalists who thought that a unitary executive, an executive branch led by one person who has full control over its operations, would lead to tyranny. Hamilton argued that the executive branch needs energy and does not need to be held back by checks and balances within the executive branch like those that exist within the bicameral legislative branch. The powers of the presidency have grown. Okay, so the powers of the presidency have grown over the years, but this has been good for the country, especially in times when the government has had to handle a national emergency. Maybe like right now. Elizabeth Denton, thank you. We've also got Johanna, Joanna. We've got Joanna over there, and then we've got let's see, we've got Luke as well. The True Jard and Satvic 210. Thank y'all so much for the recent follows. It's James, Jeffrey Cisneros, and Nat Lawton. Thank y'all so much for the support. So that's paragraph 1. We are now going to go to paragraph 2. The growth of the powers of the presidency has been accompanied by a growth in the powers of the judiciary to balance it out. So first of all, you notice here that I said that an energetic executive is beneficial to the government. And then we note here that the powers of the Supreme Court have grown as well. So the growth of the powers of the presidency, sorry, this mouse is very, very sensitive. All right. So the growth of the powers of the presidency has been accompanied by a growth in the powers of the judiciary to balance it out. Now, note here another clear and argumentative topic sentence. In New York Times versus the United States, the Supreme Court overruled the Nixon administration when the executive branch tried to keep the Pentagon Papers from being published because of, quote, national security reasons. The court ruled that just because something is embarrassing to the president doesn't mean that the media can't print it. The decision shows that even though the powers of the presidency have grown, the powers of the executive can still be checked by other branches. Now, you note here when I use New York Times versus the United States, I went and I dedicated one sentence to the facts of the case. I dedicated another sentence to the decision. So if you're going to use a Supreme Court case, make sure that you are clear about the facts of the case. Make sure you're clear about the decision. I think that it's very important to think in terms of when we are dealing with the court cases. Now, remember, you can use court cases outside of your 15. You are not limited on this question to the 15 Supreme Court cases. So if there is a court case that you know well that is not one of the 15, that is fine. So for example, if it's a First Amendment thing as far as freedom of speech or expression, Texas versus Johnson, where the Supreme Court protected flag burning as free speech. So that's Texas versus Johnson, which is not one of your 15 cases, but you could still use it on the argument essay if you know it, if you can use it. So then we see, but then again, with free speech, you can also use Tinker v. Des Moines, which is one of your 15 cases. So then, so we see here how I have, with a topic sentence, I'm explaining, okay, I'm going in here, I've got my topic sentence that ties this to the argument, and then I explain it, okay? So topic sentence, okay, topic sentence, use of evidence, and then finally, the explanation of what makes the evidence relevant, okay? And again, I could have gone into Federalist 51 here. I think I might use Federalist 51, the imbalance. Now, at the end, I will restate my thesis, but in different words than I initially stated it. So I'm not going to copy and paste my initial thesis. Restating my thesis at the end is insurance, okay? And this should not take 25 minutes to write. Just, figure out what your thesis statement is, figure out what piece of evidence will support each point in your thesis, and then you're ready to go. So let's look at imbalance now. The expansion of the powers of the presidency has been harmful to the balance of power between the three branches, okay? Been harmful to the balance of power between the three branches of government because the president has taken powers that should belong to Congress and Congress has allowed this to happen. Okay, so the president has taken powers that belong to the Congress. This is my paragraph number 1. Okay, so we think about this body paragraph 1. And then when we look here, going on from there, we get into body paragraph 2. Okay, Congress has allowed this to happen. Body paragraph. Oops. Okay, I'm trying to do shortcut keys and that didn't work. And my mouse, I tell you what, this mouse is going to get thrown away after AP season and replaced. Make sure y'all are watching the ads so that I can afford to replace this troublesome mouse. Okay, so Congress has allowed this to happen. That is body paragraph number. Okay, just take my word for it. Body paragraph number 2. I'm not going to mark it. So Article 1, Section 8 of the U.S. Constitution gives Congress many powers, including the power to declare war. This is an important check on the president's power. Now, one thing that we need to note here, I kind of forgot here that, the president has taken powers that belong to Congress. Okay, Congress according to the Constitution. Yes, and I do use Federalist 51 here. Article 1, Section 8 of the U.S. Constitution gives Congress many powers, including the power to declare war. This is an important check on the president's power as commander-in-chief, because if the president can just bring troops to war whenever he chooses, he is no different than a king, and the United States is no longer a republic. The framers designed the Constitution very delicately to create a specific balance of power between the legislative, executive, and judicial branches. In Federalist 51, Madison describes the powers of each branch and the checks that each branch has on the others. If the president can independently make war, the balance described by Madison in Federalist 51 is destroyed. So once again, topic sentence in a paragraph here, evidence. And then finally, at the end here, I will state this is how the evidence supports my thesis. All right, so that's the first body paragraph where I make the first of my 2 arguments. Brian is somewhere 0. JD Calderon. Oh, yes, Doer, you've got Baby Yoda. I love Baby Yoda. I should show off my Baby Yoda mask at some point in this broadcast, right? Dilly Boy Fresh, Lucy Funk, R.E. Nay, and Carlos Von Berg. Thank y'all so much for the recent follows, and I'll grab my Baby Yoda mask in just a second and show that off. So then we're going to say that my second argument is that Congress has allowed it to happen. Today, the president no longer needs a declaration of war to commit troops in foreign countries. And this is because Congress has allowed it, okay, allowed the president, more power than the Constitution grants, okay? Now, this is going to be an example of how we can use a piece of legislation. The War Powers Resolution, passed after the Vietnam War, allows the president to commit troops without even informing Congress for 48 hours. After informing Congress, the president can keep troops deployed overseas for another 60 days, even without the direct approval of Congress. Recently, President Trump ordered the assassination of the head of Iran's military and then just told Congress he did it after he had already done it. Because Congress did not stand its ground when it passed the War Powers Resolution, the president has turned from a commander-in-chief into a king, destroying the balance of power between the branches. Okay, so because Congress did not, so Congress gave up. Okay, what I'll note here is to make that a little bit more clear, gave up some of its constitutional authority when it passed the War Powers Resolution. Now, the thing is, remember that we can use this argumentatively, okay? Some people could say here that, depending, when President Trump ordered the assassination of the leader of Iran's military, some people could say that is an example of an energetic executive, that this man was a threat to U.S. troops overseas. Others may say that this was something that was a violation of legitimate separation of powers because the United States was not at risk of being invaded. So there are ways that you can use the same argument to, as evidence for Either side. Okay, so note that either side can be taken, and the evidence, depending on how it is used, can often be used both ways. One of my favorites is McDonald's versus Chicago. Got Wesley Willis thinking about, that's why, yeah, where if y'all look up on YouTube, Rock and Roll McDonald's by Wesley Willis, it's just like rock and roll McDonald's, and he's I think he talks about Chicago a lot. He says rock on Chicago. Y'all will thank me if you look that up. Just look up rock and roll McDonald's. Laughter gets your brain going. So that's something that would just be a great thing for you to look up. Just do it right now. Have it ready for you when you're waiting to take your exam. Rock and roll McDonald's. McDonald versus Chicago. So McDonald versus Chicago, on one hand, you can use this to argue, like based on Federalist 10, that McDonald was not given the right to use his, he was not given due process when it came to his constitutional right to keep and bear arms. So that way, when we think about Federalist 10, that we have a situation where someone's constitutional rights are not taken away from them because of the state or the city where they live. Now, on the other hand, when we look at this in terms of federalism, think about Brutus number 1. We could use McDonald versus Chicago to say that the Constitution and the doctrine of selective incorporation specifically have made it almost impossible for local communities to govern themselves. And so the expansion of the powers of the presidency has been harmful to the balance of power between the three branches of government, because they have destroyed the delicate balance in the Constitution and have also given the president king-like powers over the military. Now, one thing that I'll note here, this is one that I did on a prompt that I designed about selective incorporation and democracy. Okay, so while we're still, and we're going to look at the concept application in a bit, but I think that it wouldn't be a bad idea to go ahead and look at selective incorporation. Okay, so I'm going to put this on my screen. This is on selective incorporation and democracy. Okay, so what we have here are and what I would do, I would actually give y'all a second. I'll grab my Baby Yoda mask, and y'all can think about what would you do in terms of using one of these, or using some, what would be, which side are you going to take? Which foundational document will you use from this list to support that argument? And then what is another piece of outside evidence? So these are the three questions. Okay, so when we're thinking about that, we're thinking about the three questions. Okay, for any for any of these. Okay, so three questions. Okay, before beginning. Okay, three questions, or maybe four. Okay, so one, which side are you going to take? Okay, which documents? So which found actually, questions before beginning your essay. Which side are you going to take? Which of the three foundational documents provides the strongest support for your position? Okay, so, and y'all can, I'm going to make sure that y'all have access to this Google document here. I believe that I may have done this on a video on Marco Learning's YouTube channel. Marco Learning's YouTube channel is a great resource for videos for a variety of exams. Okay, so I'm going to go ahead and paste this in the Crowdcast chat. Okay, so we've got that, and then I'm going to note as well that we're going to get into selective incorporation. Okay, selective incorporation. All right, it's a little bit slow here. Let's see. So selective incorporation, Google Doc. Let's see. So argument essay response 2020. Then we'll put here selective incorporation. Okay, the description is currently being updated for those of you on YouTube. And while we're here, I want to thank the latest Instagram followers. We've got Allison Korn, my latest Instagram follower, McMinn NT, thank you very much. Then we've got Fridge Lettuce, Orange Guy 312, okay? Orange Guy 312, and then we see, Ashanti, Zoe, Abby, and Zane, okay, is following. Thank you, Zane, for the follow. All right, so ladies and gentlemen, let's go ahead and get to the next thing, shall we? We shall. Okay, so here originally the Bill of Rights applied only to the federal government, not to the states. In the 20th century, the Supreme Court has used the doctrine of selective incorporation in order to apply most of the provisions of the Bill of Rights to the states. Develop an argument about whether the selective incorporation of the Bill of Rights by the Supreme Court has been beneficial or harmful to the development of the United States as a democracy. Federalist 78, Brutus number 1, letter from Birmingham jail. Or it might say letter from a Birmingham, or letter from the or a Birmingham jail, but typically referred to in common parlance as letter from Birmingham jail. So you need to pick one of these three. So when we're looking at this, which side are you going to take? Which of the three foundational documents provides the strongest support for your position? Okay, so that's going to be the next thing that you're going to ask. What provides the strongest support? Now, what is another foundational document? Okay, foundational document, Supreme Court case, or piece of legislation. Okay, so piece of legislation that could provide additional support for your argument. Okay, so is there a third piece of evidence? Okay, is there a third piece of evidence that you could easily use? Okay, use to add some additional support. Okay, because that way, remember, we think of positive scoring. This is insurance. If not, don't worry about it. Okay, so don't worry about it. This is just insurance. Okay, so what are the two arguments that you're going to make to support your claim? Okay, so what are the two specific arguments that you will make to support your claim? Okay, so that way we need to think about something like this. Okay, so we're thinking about this where you're thinking about which side are you going to take? Then we're going, so which side are you going to take? And then argument 1, so you need to know what is your first argument number 1, and then argument number 2, and then supporting evidence. Okay, supporting evidence, and then argument 1 and argument 2, arguments number 1 and number 2 are going to be, so when we think about this, arguments number 1 and number 2, they are going, these two are going to be to form the lines of reasoning to support your claim. Okay, so that is where we think about what is your claim here. Okay, so then arguments 1 and 2, supporting evidence. This is the pre-writing format that I would recommend. You're welcome to copy and paste this into your own non-collaborative Google document. Okay, make sure that this is a Google document that you're not collaborating with anyone else on. Okay, because it's very important here that you are not collaborating. Remember, my newest video is going into that. Okay, so going from there, remember my latest video using other people. So, if you've got a 10-year-old daughter, you probably don't. If you're taking this exam, that's cheating. Googling something, not cheating. Okay, so who wrote Federalist 51? James Madison, not cheating. Okay, so as far as that goes, and remember, make sure that this rubric is in the YouTube description, but make sure y'all are subscribed if you're not already. Okay, make sure to hit that subscribe button so that so that you can see some other stuff relevant to AP exams. I'll likely have a reaction video to the 2020 AP government exam, so make sure that you're tuned in for that. Okay, so with that, let's go into this here. So what we're going to do here is we're going to get into the specific prompt here. So selective incorporation. We see here that this is the factual statement here, right? Basically, that the Bill of Rights did not originally apply to the states. Develop an argument about whether the selective incorporation of the Bill of Rights by the Supreme Court has been beneficial or harmful to the development of the United States as a democracy. Now, you know that you can make the argument either way. Okay, you can make the argument either way. And so with that, pick one of these, pick an additional piece of evidence, and then go for it. Okay, and you're welcome to print, the exam hasn't started yet. You're welcome to print any of this stuff out, this advice that I'm giving you. I want you to do well. Make sure you're thinking about this. Which side are you going to take? Pick one of the three foundational documents. And then what is something else that can support your argument? Is there a third piece you could add in easily? Then we think about what are the two specific arguments that you're going to make to support your claim. So with that, go ahead and fill that out. And I'm going to grab my Baby Yoda mask and show that off. And I'll do a couple more Instagram shout outs because I want you to take a moment to set this up for yourself. I want you to be able to set this up for yourself and to think about what you're going to use. Okay, so what pieces of evidence are you going to use? Which foundational document will you pick? Okay, and for those of you in Crowdcast, crowdcast.io/Tom Richey to join me in Crowdcast. I'm going to go ahead and note here, let's go ahead and put some polls here, and we're going to ask, what side are you going to take? Okay, beneficial for democracy, not beneficial for. And remember, how are you going to define democracy? Make sure to define terms. Okay, that's another thing that we want to note here that I'm going to go ahead and put here. Are there any terms that require you to define? Okay, so are there any terms that have flexible so that will require you to define them? Democracy is a very so that basically will require you to define them, let's see, that you need to define or clarify their meaning. Okay, so this would be, for example, democracy. Okay, democracy can mean a lot of different things, but yeah, here is, if I were teaching you in a in-person setting, there is the Baby Yoda mask. Okay, so yeah, I just got this a couple of days ago, and I'm really proud of it, but I can't really teach in it. Okay, so we see here most people are so we see here about 75% are saying it's beneficial for democracy. Okay, so we've got 25% saying this. Okay, so then let's go ahead and submit this as a question. Okay, so then I'm going to say here, which of the foundational documents are you choosing to use? Okay, so let's note what we've got here. Who is going to use the foundational documents? One of the three: Federalist 78, Brutus number 1. So Federalist 78, Brutus 1, and then the letter from Birmingham jail. Okay, let's go ahead and see what people are using. Okay, Federalist 78, Brutus 1, or the letter from Birmingham jail. Okay, so we see here now, this is okay. So Federalist 78 is catching up now. Okay, I was thinking at first nobody was saying Federalist 78. Okay, so as far as that goes, we've got somebody has put a thesis statement here. So let me see what we've got here. Let's see, does this work? Okay, so we've got here Zoe. Let's see what happens here. Selective incorporation has been beneficial for the development of a democracy because it protects the civil liberties and civil rights of citizens further at a state level. Does this work? Yes. What I would say here, Zoe, is that one paragraph would be dedicated to civil liberties, perhaps McDonald versus Chicago, and then another would be dedicated to civil rights, okay, which you could use the letter from Birmingham jail for that, thinking about civil rights. That would be something that I think, because democracy, when we think about civil liberties, civil rights, you've defined democracy in your terms, saying that we're talking about civil liberties and civil rights. So yeah, I would expect a paragraph on civil liberties, a paragraph on civil rights. So something like, with McDonald versus Chicago, letter from Birmingham jail. And remember, the letter from Birmingham jail and the Declaration of Independence are both expressions of American principles, where the letter from Birmingham jail defends the use of civil disobedience to resist unjust laws. Okay, so as far as that goes, there are some times that, remember, defining the terms. There are some things like democracy needs to be defined. Okay. Well, the thing is, civil rights and civil liberties, according to this exam, are two different things. So just understand, and I've got a video on this. It's very short if you want to watch it while you're waiting, because for 30 minutes, you're going to be like basically logged in and waiting to take your exam. So like I said, I recommended Wesley Willis, Rock and Roll McDonald's as just something to listen to beforehand. Then, you can also take a look at my video on civil rights versus civil liberties. Okay. And so we've got some new followers. Thank you, Scooter. Oh, okay. I'm not going to, you almost got me. You almost got me. Some people, they put these things. I almost said it. Oh my goodness. Somebody almost got me. All right. Nate Isaacs. He always reads the teleprompter. Just Motzi. We've got Ben Busha, Paul, and yes, let's see. We've got Moda as well. Thank y'all very much there. And Adriana, I hope y'all all do well on your exam today. Okay. Thank you, Emily, for the recent follow. Anchovy Element. Anchovy Elephant. Oh! That's the sound an elephant makes, in case y'all are wondering. All right. So as far as that, oh, yes. Okay. Mr. Andrews from Cal High in San Ramon, California. I met Raul a couple of years ago, and Raul, best of luck to you. Raul Dish Panda, who is, always having great interaction with me on Twitter. Also at Tom Richey. If anyone wants to follow me on Twitter, I can see if I've got any new followers on Twitter to shout out to as well. Okay, so we've got, let's see, I don't know if I've got, so Peace just followed me. We've got Kate just followed me as well, Chelsea and Carrie and Jeff at Tom Richey on Twitter. Thank you so much. Okay. So with that, ladies and gentlemen, yeah, Raul, it is so good to be able to guide you on the last leg of your AP journey. So with that, ladies and gentlemen, let's go ahead and take a look at what I've got here. Okay, so taking a look at some sample responses. So just make sure that we define things. I think democracy needs to be defined. So when we think about selective incorporation, this is the application of the Bill of Rights to apply to the states. Democracy will usually be in terms of majority rule and or equality. Okay, so when you think about that, when we think about what democracy is, now civil rights and civil liberties, that's fine too. But as long as you define it clearly, what you're choosing to mean by democracy, what democracy means to you, as long as the definition is defensible, then you're good. Okay. So one thing, what I'm looking at as the basis of the pro argument is selective incorporation has been beneficial to the development of the United States as a democracy because it has created more equality and has instituted majority rule. Okay. Let me make sure that I've got my screen share maximized here. All right. So as far as that goes, we see that. Now, the con, selective incorporation has given a small group of judges the ability to influence policy regardless of how the majority feels about it. Now, one thing to note is a lot of Supreme Court decisions have been, have not been that popular. If we think now, public opinion is not on this year's exam, but popularity of Supreme Court decisions, New York Times. Okay, so for example, one thing that we would note here, let's see, I don't opinion. Okay, I'm actually not able to find that, but first of like Engel versus Battelle, which said that you can't have prayer read in public schools. That was only approved of by about 30% of the population. Texas versus Johnson, the flag burning case, where the Supreme Court said that burning a flag is protected speech. Only about 20% of the country agreed with that decision at the time. So you could go into the undemocratic nature of the Supreme Court. Brutus number one, it would be a great thing to use for that. Now, so what I'm doing here on the pro side, Federalist number 78, the least dangerous. Remember that Federalist number 78, a couple of takeaways here. First of all, Hamilton says that the Supreme Court will be the least dangerous branch in impacting the liberties of Americans. Okay, so it'll be the least dangerous. Also, he is going into the, he's getting into, let's see, so we've got here where Nate, okay, excellent. So, Nate is out there. So Sam, Eric, Chuck, Holly, thank you so much for the recent follows on Twitter. So with this, your evidence is going to depend. Now, note here, Federalist 78, we've got two things. First of all, least dangerous. Second of all, we see an independent judiciary. Now, we could also say maybe rights are upheld, but in a way that's undemocratic. Okay, the letter from Birmingham jail, the courts sometimes do what is just, but maybe not popular. Some other things that I'm noting here. So these are some things that we could bring in. Remember that bringing in a third piece of evidence, just as insurance, if you have time, not a bad idea. So we see here that I've got 4 possible pieces of evidence that I put together here. Now, remember, you're required to have 2. I recommend a third. A fourth would just be extra. If you've got time, I wouldn't recommend it, but I want y'all to see the way that I use evidence. So I may be using more evidence that's necessary, partly because I want y'all to see how I'm using it. Selective incorporation has been beneficial to the development of American democracy because it has increased the freedoms of Americans under the Constitution. Okay, so we see here paragraph 1. When we're thinking about body paragraph 1, there you go. And so let's pick up this troublesome mouse again. Oh my Lord. Okay, so okay, and then it is also kept local factions. Okay, it's also kept local factions from violating constitutional rights. Okay, this is going to be body paragraph 2. All right, so going into that. So the first paragraph, because of selective incorporation, Americans have more rights than they would have had if rights were only protected by the states. Topic sentence, okay, making the argument clear that what's going to follow is supporting my thesis. Alexander Hamilton wrote in Federalist 78 that the judiciary would be the least dangerous branch of government in terms of hurting Americans' liberties, and that he has been correct because the Supreme Court has ruled in favor of freedoms that were not protected by the states. In Brown v. Board, the Supreme Court overturned state segregation laws as a violation of the Equal Protection Clause of the 14th Amendment. Without selective incorporation, we might still see racial segregation in some states today because Congress had been unwilling to tackle the issue before Brown v. Board. It wasn't until after Brown that Congress started passing civil rights acts. The Supreme Court took the lead in promoting equality for all Americans. Now, as far as that goes, when we look at, Brown v. Board, what if the reading guidelines were really strict and they said, well, Brown v. Board, that's about the 14th Amendment, not directly applying the Bill of Rights. That's the sort of thing that's the reason I recommend a third piece of evidence, because what if something happened? Make sure y'all are following Marco Learning on Instagram as well. They've got some great stuff, a lot of great jokes, a lot of good AP humor. So I would follow at Marco Learning on Instagram as well. And so, with that, it wasn't until after Brown that Congress started passing the Civil Rights Act. So in case the reading guidelines are stringent, it's like, well, that didn't involve the Bill of Rights, okay? So with that, we will see here as we go to body paragraph 2. Remember, we are still on the pro, okay? So let me just run in here. And those of you who are following Marco Learning, I'm going to ask them to send me some screenshots so that I can shout y'all out as well. Okay, so please send screenshots of new IG followers. Okay, so followers, so I can shout out. So if you're following Marco Learning on Instagram, we can get a shout out there too. All right, so going from there, Selective incorporation keeps local majorities from taking away constitutional rights that the majority of Americans support. In Federalist 10, again, topic sentence. In Federalist 10, Madison wrote that a large republic is beneficial because it keeps a single faction from controlling the government in a way that is possible in a smaller republic like a state. Federal courts can apply the Constitution in a way that state courts cannot. In McDonald versus Chicago, the Supreme Court ruled that McDonald's Second Amendment right to bear arms had been violated by a local law that made it almost impossible for a resident of Chicago to legally own a handgun for self-defense. Even though the majority of Americans favor stricter gun control than we have now, the majority also supports the Second Amendment in general. Now, note here, there's lots of polling data. Of course, public opinion is not explicitly on the exam, but you see where I'm using public opinion to boost my argument here, which you're certainly welcome to do on the argument essay. You can use public opinion to boost your argument. When you look at polls about guns and the Second Amendment, the majority of Americans would like to see stricter gun control measures, especially in terms of background checks. But the majority also opposes banning handguns or banning rifles. So the majority of Americans support the Second Amendment, but they also support stricter gun control measures. Now, you can make this argument serve you, right? In protecting McDonald's right to bear arms from being taken away by a local majority, selective incorporation helped to preserve a constitutional right for all Americans, regardless of where they live. So that is democracy. Okay, so we've got some new Marco Learning followers. We've got Eric Chin 01. All right, my friend Raul Dish Panda again. Paige Besman, Alex Renzoni. So Katerina Luciana. Jay Mulberger. Okay, so we've got some new followers at Marco Learning. Thank y'all so much there. We've got, okay, I'm not going to read that one. Okay, y'all, those of you that are trying to get me to read stuff, y'all crack me up. Kaylee Hannigan, Corey Fairman, we've got Henry Bell and Christy Marie. All right, and Jake the Great. And Luke, thanks so much. I already shouted out to you. I recognize you there. Okay, so as far as that, we've got some folks here. Yeah, so we've got all kinds of great, great people here. So thank y'all so much. Well, actually, you're going to thank me because Marco Learning's got some really funny content on their Instagram. So with that, again, a sentence at the end explaining why this evidence supports my thesis, okay? So a third piece of evidence, just in case somebody's like, well, Brown v. Board was about the 14th Amendment, not the Bill of Rights. If you put a third piece of evidence, you don't have to get so technical. So selective incorporation has been beneficial to the development of American democracy because it has led to the protection of equal rights and has kept local majorities from taking away the constitutional rights of Americans. So then we go on to the con, okay, which we're going to use Brutus number 1. Now note here, I'm intentionally showing you how to use McDonald for both sides. Okay, so McDonald can be used on either side of this argument. McDonald is one of my favorite cases because it is something that has clear arguments for both sides, especially on this question when we think about what is democracy. Is democracy the nation having its way, or as a federal republic, does democracy matter when we think about majorities in the state? So when you think about gun laws in Wyoming versus gun laws in New Jersey or California. So these are states that we have sparsely populated states, and then we have states with a lot of cities, a high urban population where people are more likely to support gun control and strict gun laws. So with that, my thesis statement, selective incorporation has been harmful to the development of American democracy because it has kept the people of the states from making laws that benefit them, and has also, I tell you what, my daughter, you want to say hi, Caroline? Okay, Caroline is on my recent video. Caroline, who wrote Federalist 51?
Alexander Hamilton.
No.
James Madison.
Who wrote Federalist 70?
Alexander Hamilton.
Who wrote Federalist 78?
John James.
No, John. We're not doing any John Jay. Okay, John Jay close. Hamilton wrote Federalist 70 and Federalist 78. James Madison wrote Federalist 10 and Federalist 51. Yeah. But tell them who wrote the Federalist Papers.
James Madison, Alexander Hamilton, and John Jay.
All right. I tell you what, that is all. Oh, that's okay. All right. So you know what? If I could have a daughter that could get a high five right the first time, or a daughter who could name the authors of the Federalist Papers at 10 years old, I'm going to take the latter. So very good, Caroline. Thank you so much. She's going to be taking AP Government maybe in about 7 or 8 years. So as far as that goes, selective incorporation has been harmful to the development of American democracy because it has kept people from the states from making laws that would benefit them, and has also resulted in some decisions that have undermined majority rule on a national level. So note here that what I'm doing is I'm framing this in terms of majority rule. Okay, so it has kept the people in the states from making laws that benefit them. Okay, so basically it has undermined federalism. So body paragraph 1 will focus on federalism. Okay, so when we think about democracy at the state and local level, okay, which we see that selective incorporation could be argued to destroy that. And then we see here that then I'm going to say it's also undermined, okay? So some decisions that have undermined majority rule on a national level. So we see here that what we'll get into there is that we've got these decisions here. So the second body paragraph 2, will focus on democracy on selective incorporation, impact on democracy on the national level. Okay, so on the I'm gonna say, I think at is the word I'm looking for there. All right, so with that, ladies and gentlemen, so going from that, selective incorporation undermines the ability of states to make laws that are best for the citizens of that state and are popular within the state. Again, this essay is going to focus solely on majority rule. And remember that Brutus #1 is an anti-federalist. Brutus is writing in terms of he doesn't trust the federal government, okay? That he thinks the Constitution is going to create a national government, okay? So when we think about this, one thing we want to note here, that when we think about the Federalist Papers, let me just go into, I think this is a good thing for us to focus on quickly, is when we think about the Anti-Federalists and the Federalists, okay? So on one hand, the Anti-Federalists, they say that the Constitution is neither federal nor Republican in form, okay? If neither federal nor Republican in form. Actually, you know what? Let's do an unboxing. Okay, so we got an Amazon package, and I think if this is what it is, it's kind of relevant here. Oh yes. Okay, so the thing is, some of y'all might remember a couple years ago when I did like Supreme Leader. I've got a Kim Jong-un shirt for Thursday night's 8-Push broadcast. I got a shirt like Kim Jong-un. Thank you, Caroline, for that unboxing. Also got some flax seeds, great source of omega-3, which is good for your brain. All right, so going from there, wherever you want. All right, so as far as that, anti-federalist, the Constitution is neither federal nor Republican in form. The Constitution will create a government that is national and autocratic, that is beyond the reach of the people. Now, the Federalists are arguing that the Constitution is both federal and Republican in form. The government created by the Constitution is neither national nor autocratic. So no matter which Federalist paper we're talking about, we are getting into this idea that the Constitution, first of all, does not destroy the states, that it maintains federalism. And then we see also that the Constitution does not take the government out of the hands of the people. And so that's just something you want to note there. A federal government reserves some powers and sovereignty to the states. A Republican government is a government that is responsive to the people, okay? So when we look at Federalist 10, which those of you in the Crowdcast, I'm going to go ahead and let's go ahead and share this so that y'all have access to it. Okay, so we're going to share that so that you have access to it. So with that, we'll go ahead and get in here and put that for y'all so y'all can share. I'm going to put this in the YouTube chat as well for those of you who are watching live. Okay, best Kanye album, Jesus is King. I tell you what, when I got to get my mind right, I tell you, if I were taking an AP exam, I'd have Jesus is King going. Okay, Life Slayer, good one there. I'd have Jesus is King going to get my mind right. You know, Wesley Willis, then Jesus is King. I tell you, that's an amazing album there. Kanye wants y'all to get a 5, ladies and gentlemen. Just remember that. It's very important to Kanye that everyone makes a 5. So when we look at Federalist 10, okay, so notes on Federalist 10, we're seeing here there will be factions in any Republican government. Now, when we're thinking about factions, Madison's arguing in Federalist 10 that we want to control factions. And so political parties and interest groups, okay, whereas political parties, a broad coalition of voters who come together. And they elect candidates to office. They have a platform, a collection of issues, okay? Then you've got interest groups. Now, interest groups such as the NRA, the National Rifle Association, which is a gun rights lobby. Now, we notice that the political parties, the Republican Party tends to support gun rights, while the Democratic Party tends to support gun control. And so we see that parties align themselves with interest groups, but we want to note that, you know, those are different. Interest groups tend to be single issue. Also remember, partisan means party. Ideology has to do with your beliefs. So conceivably, I mean, somebody can be a conservative Democrat, a moderate Democrat. Certainly, we don't hear people saying that Joe Biden is a progressive Democrat, you see? So a Republican, you can have a liberal Republican. They're rare, but they exist. So remember, when we talk about political parties, interest groups, and political ideologies, I've got here some interest groups that tend to be courted by Republicans. But remember, a Republican can be pro-choice, all right? A Republican can support gun control. You know, Republican can support immigration. Okay, so those are things that are important. Now, there are Democrats who are gun owners. There are labor union members who vote Republican. In fact, I think most, you know, when you look at members of labor unions, they're more likely to vote Republican than the leadership of labor unions who typically support Democrats. Now, immigrant rights groups, whereas a Democrat can favor strong border controls. Okay, so remember partisanship and ideology. Okay, so as far as that goes, when we're thinking about that Madison is responding to Brutus's claim. In Brutus #1, he claims that, Brutus #1, there is this claim that that only a small republic can preserve Republican government, that in a large republic, the elites, that's where we get into the elite theory of politics. In a large republic, elites are going to take over, okay? And that they are going to destroy the power of the people. Now, Madison says that, look, that a faction, when we look at a bicameral legislature and we look at the large republic, we see that, no one faction can dominate. So Madison is going against conventional wisdom, that the anti-federalists say only a small republic can preserve republicanism. But Madison says only in a large republic can we really keep a single faction from gaining control. Now, pluralism and hyperpluralism, it's all about what you think of interest groups. Pluralism says that all these interest groups, they keep one group from dominating, and that's good. That goes along with Federalist 10. So Congress won't pass any radical gun legislation. When we look at pluralism, Congress will not pass any radical gun legislation. Whereas you notice, like in Virginia recently, there were a lot of laws passed about, with new forms of gun control. Now, on the other hand, hyperpluralism, Congress can't pass any meaningful legislation because all of these groups are working against each other. So that's just something to kind of get into with Federalist 10. So back to what we've got here is the con essay. We're going to use Brutus #1, McDonald versus Chicago, Ingle versus Vitale, and we're going to focus on democracy as majority rule. Selective incorporation undermines the ability of states to make laws that are best for the citizens of the state and popular within the state. In Brutus #1, an anti-federalist argued that the creation of a federal judiciary would undermine the state courts and take away their dignity. Brutus believed that the Constitution would turn the United States from a federal republic into a single nation, and that is exactly what selective incorporation has done by giving the Supreme Court the power to overturn state and local laws. An example of this is McDonald v. Chicago, where the Supreme Court declared that state and local governments have to allow residents to keep firearms in their homes, even if that goes against the wishes of the majority of people in a state or a local community. Allowing someone to have a gun when the majority of the community doesn't want anyone to have a gun may be constitutional, but it is not democratic. So you see where I've used McDonald versus Chicago both to support the statement or oppose the statement. So I can support selective incorporation, I can oppose it, depending on how I'm defining democracy. And let me shout out before going to the second body paragraph. We've got some new followers at the Marco Learning account on Instagram, at Marco Learning, Drew, HO2, and then B, Yasmin, Alexander Gonzalez, Daniel Stormtrooper, Ashley High T. I've got some High T, and Mustafa and Faye Nicole. And I'll be looking at my Instagram as well and make sure that we are getting, that we're continuing to follow Marco Learning, Tom Richey for updates on AP exams in general. Thank y'all so much for the support, and thank you, Alex Zangalang, for your recent your recent follow. And we've got y'all are trying to get me to read stuff. All right, and that one wasn't even funny. All right, so in addition to undermining the wishes of local majorities, selective incorporation has also allowed the Supreme Court to undermine the wishes of national majorities. One of the court's most controversial decisions was Engel versus Vitale, in which the majority of the court voted to overturn local school prayer, even when students were not required to say the prayer, and the prayer said nothing about Jesus or the Christian religion. The Engel decision was only supported at the time by 30% of Americans. 9 people got to overrule 70% of the American population that supported public school prayer at the time. This could be part of the reason why the United States has grown less religious since the 1960s. The Supreme Court doesn't have a right to direct the future course of American culture. Okay, so you see here, this is why it's relevant. This is what I'm arguing. Okay, this is how I'm making my thesis statement. This is my evidence. Okay, and then we see here, this is why it is relevant to the prompt. And again, I'm going to restate my thesis. Selective incorporation has not been helpful to the development of American democracy because it has undermined the ability of states to make laws that are appropriate for the majority of their citizens, and has resulted in the Supreme Court making some decisions that have been unpopular with the vast majority of the American people. So when we look at this here, now another one is, Kennedy versus Louisiana, where, this was something I believe that even, President Obama, a Democrat, where this was a decision where the Supreme Court, I believe on a 5-4, they said that Louisiana couldn't execute someone who had brutally raped a child. And this was a very polarizing decision because this is something that, the vast majority of Americans would say that that person needs to be executed. And so that's something we've got. Oh, we've got a super chat. Thank y'all. Let's see, Magazog, let's see, against the lockdown. Okay, so all right, thank you so much for the super chat there. That's very interesting. Okay, so with that, we got a lot of people in the YouTube chat. That thing is moving quickly. Crowdcast, we've got a smaller group. Remember, crowdcast.io/Tom Richey. All right, so okay, so when we think about this, when we think about quasi-legislative and quasi-judicial powers of the democracy or the bureaucracy. So the bureaucracy, these are people in the executive branch that get to basically decide how the laws are going to be enforced. So, for example, those of you who follow me on Twitter know that I'm constantly complaining about my neighborhood pool being closed. The governor of South Carolina has said that public pools will be closed. And DHEC, which is the Department of Health and Environmental Quality, they've decided that a neighborhood pool will be considered a public pool. You go to my neighborhood pool, it says private, residents and their guests only. It's like in South Carolina, I can go to the, to a clothing store that can be open right now with social distancing, but my neighborhood pool is closed. I got an email from DHEC that's saying that we have interpreted the governor's order to apply to neighborhood pools where only small groups of people have access. So we see here that you've got this bureaucratic discretion where the governor put out this declaration, and then this bureaucratic organization says that this is how, this part of the bureaucracy, the bureaucrats decided this is how we're going to interpret what the governor said, or this is how we're going to pass these laws. Like the FCC, basically they can do their own directives. The Federal Communication Commission, we want to think about independent agencies such as the FCC, the Federal Communications Commission. They get to basically make rulings about things like, for example, net neutrality. Can internet service providers slow down certain websites and promote other websites, or does that need to be strictly controlled? And the FCC, they can say, we are going to set policy. Now, the FCC, these are people who are on the board who have been nominated by the president. They've been confirmed by Congress. At least 2 members of the 5 have to be from the other party, but they really have a lot of leeway. When we look at these independent regulatory agencies and the bureaucracy, they get to make decisions. It's just like when you get pulled over and the police officer said, the police officer can write you a ticket for going how fast you were going. They can write you a ticket for going less, or they can let you off with a warning. That's something that, every time I get pulled over, I'm sure to tell the police officer I'm a teacher. I'm like, oh yeah, I try to fit it in that I'm a school teacher, so that I can get some sympathy, because I know that police officer has some discretion as to how he or she will enforce the law. Okay, so going from there, thank y'all again for all of the support on Instagram. Yalthi, let's see, Kat Racha and Moda, thank you so much. Thank you everybody for that support. Y'all are being so good to me, and hopefully I'm being good to you and getting y'all ready. Now, we also need to think about the concept application question. Okay, the concept application question. So going from there, we've got the concept application. So the concept application is the other part of your exam, and what we want to note here. Let's see here that we need to make sure. I need to pull that up again because some of y'all have joined us more recently. On my Instagram, I've posted where we've got the timing for the AP US government exam. So at Tom Richey on Instagram, I've got this great graphic from my friends at Marco Learning. And again, they post such funny stuff right now. I would subscribe, even if this is the only AP exam you're taking. I would follow Marco Learning just for the jokes. So the timing guide for the AP US government exam, 30 minutes to log in. Okay, so at in about, well, it's getting close now, that you need to log in at 3:30 p.m. Eastern time. Now, 25 minutes for the argument essay. The red light will start blinking. 5 minutes to upload. Then we've got the concept application question. Now, remember, I found my free practice exam at Marco Learning. So we see here on the concept application, and again, we've got some explanatory stuff here, and then we're going to ask, how would we interpret this stuff? So, although the Supreme Court affirmed the legality of capital punishment in 1976, executions are performed unevenly across the nation. Executions are currently used by 28 states, the military, and the federal government. Death penalty statistics demonstrate that executions are disproportionately high for the population in some states, such as Texas, and lower in other states. Minority groups also face higher rates of execution. In addition, men are more likely to be sentenced to execution than women for the same crime. The National Coalition to Abolish the Death Penalty argues that uneven application of the death penalty is an arbitrary and capricious practice that violates the equal protection clauses of the U.S. Constitution and the U.S. Constitution. The National Coalition to Abolish the Death Penalty urges its followers to engage in lobbying efforts at both the state and national level. After reading the excerpt, please respond to A, B, and C below. So this is just like an A push, like short answer or something like that. So when we're thinking about that, the concept application, okay, so what I'm going to do is we're going to send that to Crowdcast. I'll put that in the YouTube description as well. Okay, so going with that, let's go ahead and share some love with my friends here on Crowdcast, and then go over to YouTube. Okay, so as far as that goes, says we've got an excellent connection, but it looks like it's okay. So I think we're okay now. All right, so I just need to update. I just need to do a little update here to put this, we're getting a little slow on YouTube. Let's see, concept application. Okay, the YouTube description is being updated. All right, so we have saved that. The YouTube subscription is updating. Okay, so as far as that goes, let me close out some tabs, make sure that we are, have the minimum amount of tabs open. And let's see, remember, my argument essay rubric is available. And of course, give me a follow on Instagram if you're finding this to be helpful. Okay, so make sure that this rubric is in the YouTube description. If you want to print that out, that is an excellent thing to do. It's an excellent choice there. Now, as far as what we've got here, describe an action. Okay, so if we're thinking about this, we see here, okay, so yeah, we're looking at our sample thing here. All right, so describe a specific action that Congress could take to address the concerns of the National Coalition to abolish the death penalty. We have to keep in mind separation of powers. We also have to keep in mind federalism, okay? So with this, Congress could pass a law that would abolish the use of capital punishment for the federal crimes and the military. So we think about what can Congress do, what can Congress not do. So incorrect, Congress could pass a law that would ban capital punishment throughout the United States. Congress has no authority to control the use of capital punishment in the United States when it's been upheld by the Supreme Court as constitutional. Now, Congress could allocate grants to states whose governors are willing to commute sentences for death row inmates to life imprisonment to help subsidize the cost of life imprisonment. The best way Congress has to get the states to do something it wants is to throw money at them. Congress could allocate grants to states. Okay, so Congress could also allocate grants to states that wish to perform studies of the impact of capital punishment in their states. Congress could allocate a quota. Now, this would be incorrect. Okay, this is incorrect. Congress could allocate a quota system to make sure that the same percentage of men and women are, executed, not executives, executed. We're dealing with with typos here. That'll be an issue on your exam as well for the same crime and also for whites and non-whites. Don't do that. Okay. The Senate could refuse to confirm justices to the Supreme Court that support capital punishment. Okay. So they could say that, or have a record. Okay. Or have a record of supporting, okay, capital punishment. Remember that there's nothing stopping the Senate from telling the president, look, we want a person with a certain ideology. Now, the House of Representatives, that would be incorrect. This would have to say the Senate. Congress could propose a constitutional amendment that would ban capital punishment and send it to the states for ratification. Now, we can't say Congress could amend the Constitution. Congress cannot amend the Constitution. So what we want to note here is on the concept application, you need to be accurate and specific, okay? So we see here, Congress could create an ad hoc or joint committee to hold hearings about the application of capital punishment in the United States. So to hold public hearings, okay? So publicly televised hearings about the application of capital punishment in the United States. So basically looking at something Congress can actually do that doesn't go beyond their power. The biggest thing is federalism. They cannot outlaw capital punishment across the United States for state crimes when the Supreme Court has upheld it. What is being tested here? What powers does Congress have? And what powers doesn't it have? Okay, so we're going to note here, the second one here is in the context of the scenario, explain how ideological divisions about the death penalty could cause partisan divisions. Okay, so we could say here, when we're thinking about this, how could they cause partisan divisions? Okay, so things here that we could say, we could go into ideology and partisanship. Okay, so since people who support the death, so Republicans are much more likely So more likely to support the death penalty than Democrats. Okay. It would likely, legislation to end the death penalty would likely be opposed by most Republicans in Congress. Okay, so we could see that, or we could do the reverse of that as well. So, or you could say here, a member of Congress who is a Democrat but comes from a conservative state or district would likely break with their party and support the death penalty because it goes along with the beliefs of the people in their state or district. You could combine these two in order to have a stronger answer. You've got a lot of time. You've got basically, 5 minutes for each one, almost, when you think about reading the question. So do more than one sentence, okay? So, don't write like half a page for each one of these, but I would encourage you, use more than one sentence. Make sure you do something that is clear. Remember also positive scoring. It may not hurt if you've got time to put, another explanation, because you're graded on what you got right, not penalized for what you got wrong. Now, the third part here is explain why death penalty advocates might argue that allowing capital punishment is in accordance with the U.S. Constitution. And remember, if this is helping you and you're on YouTube and you haven't subscribed yet, please hit that subscribe button, give this a like and a comment. So with that, how could someone argue the death penalty is constitutional? The 8th Amendment prohibits cruel and unusual punishments. Since the death penalty has never been unusual and is typically applied in ways that minimize suffering, it is in accordance with the Constitution. Okay, so then we could go into the 10th Amendment. Since the 10th Amendment reserves all powers not delegated by the federal to the federal government to the states and the people, capital punishment by states cannot be considered unconstitutional, since nothing in the Constitution stops a state from executing criminals. Someone who is an originalist could argue that the original intent of the framers of the Constitution or the 14th Amendment was not to outlaw capital punishment. Then it could only be outlawed by an amendment to the Constitution. Now, something like capital punishment is a legitimate power of government because of the necessary and proper clause. Okay, that's not going to work. Okay. So as far as that, make sure that you're noting the specific powers of Congress. Are people are pressing F to pay respects? Is that because of your you're playing to fail? I hope y'all aren't playing to fail. A lot of people are pressing F to pay respects. I hope that is Harambe, because if Harambe wants you to pass, you are going to pass. And remember, Kanye wants everyone to get a 5. My goodness, that live chat is going so fast. All right. So I'm glad to hear that is helping, Raul. Again, it was a pleasure to meet you a couple summers ago when I was in the Bay Area, and it's such an honor to be able to help you along with your AP journey. All right. So as far as that goes, federal legislative powers. Now, one thing I might recommend, Theodore, is to take a look at my video on the Senate versus the House. Okay. Now, we need to be getting ready to log into the College Board interface here. Okay. So we need to make sure that we are getting into that we're ready. I would go ahead and pull up that page and get ready to log in. They're recommending that you log in 30 minutes in advance. Okay. So as far as that goes, let me go ahead and get in here and we'll talk about the Senate versus the House. Okay. So let's look at the Senate versus the House of Representatives. Okay, so we're going to look at the Senate versus the House, and we're going to review. I think this is going to be very helpful because we need to look at, we need to think about, are these powers, okay, that these branches of government have. Okay, so with that, let's go ahead and take a look at the Senate versus the House. So with that, we're going to note here that the Senate is the upper house. There are 2 per state. Remember, if we're thinking about the Constitutional Convention and the compromises that were reached there, this is the federal house. This is the house where every state, California and Wyoming, are represented equally. That we see, this is the federal house, 6-year terms. The Senate is intended not to be as immediately accountable to the people. Remember, the point of the Constitution was to create a balanced government, okay? A balanced government that is going to, have a democratic element, but where members of the Senate can, more use that trustee model of representation rather than the delegate model of representation. Okay, so that's something that would be, useful for you to think about there. All right, so as far as that goes, we see insulated terms, 100 total. Now, the vice president chairs the Senate. The vice president's not a member, can only vote to break a tie. Unlimited debate. The Senate is where you have the filibuster. Okay, that is where you have the filibuster because unlimited debate and unlimited speaking times. Okay, so the senators, when they have the floor, they speak for as long as they can hold it. Okay, so they speak for as long as they can hold the floor. Is Instagram going down? It's telling me that it can't load activity. I wonder if Instagram is crashing along with the along with the situation at the College Board. Okay. So as far as that goes, the filibuster happens in the Senate. An impeachment trial happens in the Senate. We've seen that a few months ago. Now, the filibuster, we think about now, senatorial courtesy is actually a word that's typically something else, but we think about the filibuster is that, we see here that a courtesy to speakers. Now, also nominations, okay? So when we think about, nominations, that is something that is important as well. Now, senatorial courtesy, typically when the president nominates someone, then nominates like a federal judge for New Jersey. If the senator from New Jersey is a member of the president's party, the president will typically get that person's okay. Okay, so that's something to note there, that the senators also have some say and who gets nominated to be federal judges. That's unofficial. That is a courtesy from the president. Okay. So as far as that goes, we see here that the girl in a pineapple world. Okay. So we see a girl in a pineapple world. That is an interesting Instagram handle. All right. So thank you, Chase and Yasmin, for the follows. So with that, nominations, judicial, cabinet, ambassadors, all of those have to be confirmed by a majority of the Senate. So make sure that when we look at that, we are looking in terms of, that these all have to be confirmed by the Senate. So, when we think about these confirmations, I think, when I look at my work, I always think in terms of how can I make this a little more accurate. Okay, so confirmation. So when we look at confirmations, that is a Senate majority required to confirm. Okay, so a Senate majority required to confirm, folks. Okay, so with that, we see that what we've got there. Now, when we look at the House, okay, so when we look at the House, what we're going to see here, when we go to the House of Representatives, the House is the lower house. That is proportional representation. The large states are represented more there than the small states. It is a national house. We also see 2-year terms, which the House of Representatives is the most democratic branch of, part of our government. The House of Representatives has a national population. It is proportional to the states. So all the districts are about the same size. 2-year terms so that the representatives are accountable to the people they represent, frequently held accountable. 435, chaired by the Speaker of the House, who is a member and can conceivably vote if the Speaker wants to. Limited debate. So the House has limited debate while the Senate has unlimited debate. And that is, of course, a product of a product of this system. And then we see here articles of impeachment. The House drafts articles of impeachment that go to the Senate for trial. Now, basically, the only unique power that the House has is revenue bills must originate in the House. Revenue bills having to do with taxation, that the Senate cannot initiate a revenue bill. Now, the revenue bill has to be passed by both the Senate and the House in order to become law, but it has to originate in the House to make sure that the people are being represented in terms of taxation. So the Senate, because it does not represent the people proportionately, cannot originate a revenue bill. So that's where we look at the Senate and the House. Okay. Also, Madison noted in Federalist 51 that the bicameral nature of the Senate and the House is because if it were unicameral, Madison said it would be too powerful. And so as far as we look there, Are we allowed? Okay, quoting from the documents. That's not going to help anybody. It's not going to help anybody to quote from the documents. So make sure that you're showing your understanding. Your reader knows what the documents say. Quotes will not help you. You have to put it in your own words. Okay. So as far as that goes, ladies and gentlemen, last call for Instagram shout outs and all that. I'm about to call it a broadcast. Thank y'all so much. Jason Land for the recent follow. We need to go ahead and start opening up the College Board page. I'm so happy to see y'all, gosh, the chat is lit. Okay. Thank y'all so much for your support there. Hopefully we've got some new subscribers. If this has been helpful to you, make sure to subscribe. I will be putting at some point a reaction. People are predicting their scores. Okay. A 0 is not an acceptable AP score. All right. So let's see if we've got, okay, it looks like most of you are going to follow or following, but stay tuned for updates. I will be at some point giving my reaction to the AP government exam. So thank y'all so much again for your support. For some of y'all, this may be like the third exam journey that we've taken together. So I'm so glad to give y'all some last minute kind of encouragement. So best of luck to everybody, ladies and gentlemen. At this point, you should be logging in to the College Board website. Dragon Energy, it's a written test, or I guess this year, a typed test. Okay, yes, Dragon Energy, you got this. Kanye wants you to get a 5. Kanye's with you. Harambe's with you. All, everybody who needs to be with you is with you. And stay tuned. Once I know that I can talk about the exam, once it's over, at some point I will do a reaction video where we'll kind of go into what I'm thinking about this. But yeah, and thank y'all. Yes, Baby Yoda is putting, imagine Baby Yoda in his pod, okay? He is with you. Baby Yoda wants you to do very well, okay? Baby Yoda tells everybody, well, actually, he doesn't really talk, but Baby Yoda is going to use the Force to help you, okay? So make sure, yes, and thank you, Theodore, for all of your support. It's really an honor to be able to help so many people prepare for these exams. And so with that, just best of luck to everyone. If you're taking exams in the future, let me, just keep me in mind, your siblings, your friends, all of that stuff. So y'all go get this. And, I'm looking forward to hear how y'all do on the exam. It's always a pleasure.